Okay, so welcome to Probate Weekly. And, failing to plan is planning to fail. One of the areas that I saw when I went to court every day up until COVID was just the nightmare, in particular, of special needs and guardianships and conservatorships, in particular in probate, that when you don't plan ahead, that area, I think, where you have the most vulnerable and maybe needy clients are the ones that suffer the most because they're just unable to really handle that. And I'm excited today to have an attorney who focuses a lot on estate planning for special needs to avoid that scenario. Jackie Kerr. Jackie, thank you for joining us today.
Thanks for having me, Bill.
What got you into special needs estate planning in particular? It's a pretty narrow niche of estates and trust, and then estate planning, and then special needs estate planning, obviously is a niche of a niche of a niche. What got you into that?
So a number of years ago, I was planning on having one baby, and I had two, and they were born prematurely, and they had a lot of special needs. And so I went from being a trial attorney and in court every day to a mom with two children who had very special concerns, and a mom who was worried about the future and how we were going to support these two children and the needs they might have that might exceed the needs of your average child.
So if you might talk a little bit about what that is, because I think for those of us who don't have special needs children, we're not really exposed to it that much. I have a good friend who actually is a attorney specializing in this area, so I have a chance to look in it a little bit as a business point of view. But what are some of the major issues that you have to deal with that are unique with special needs cases?
So in special needs cases, what we want to make sure we do is, first of all, we want to make sure there's sufficient funds available for a child who may not be able to live independently in the future, for a child who may need supplemental assets available to pay for extra help in the home, extra services, companion services, and things like that when the parents are gone or no longer able to take care of them. Right. So financing the future of these children becomes a very big concern of most of my clients. And the other big concern is when special needs children or going into special needs adults, people who are on disability, for example, people who are receiving governmental benefits for their housing, their day hab, their educational purposes, and their home care, their attendance, they can lose all those benefits if they inherit money directly. So for those families, we want to make sure that we are not only finding strategies to provide funding for those family members, but also strategies to make sure that money is secured and doesn't interfere in the benefits that they need every day.
So let's package a few things there. So first off, just in general, I don't think I'm only aware of it because of my friends, that the simple process of who's going to write the rent check or the mortgage check or the property tax check or the insurance check, who's just going to do that can become monumental when the parents are no longer around, right?
Exactly.
Simple things that otherwise are normal everyday activities. And you say, well, that's not such a big deal. Writing a check. Yeah, you have auto payment on an account. Well, if that account changes, the bank closes, somebody has to reorient the whole process all over again, right? And so those are where, who's the one who steps in and makes that assessment? Who's the one who's in control of those decisions at that point?
So it depends. There are a few things that we can do. For a lot of parents with special needs children, when the children turn 18, they move for guardianship of the child. And they do that so they can continue providing the same level of support they're able to provide as parents. If there's a guardianship in place and a parent becomes incapacitated or is no longer able to act as the guardian, they can name a successor guardian. Sometimes a sibling or another family member, somebody like that. And that person would have the authority to pay the bills, apply for governmental benefits, make sure housing stays secure, and all of those things you think of parents doing for their children. So that's one way to deal with that.
So theoretically, if you set up properly with a guardianship, they can provide all the same kind of oversight, administrative support that, say, a parent might for a child.
Exactly.
Or similar. And that's a process where if they're a conservatorship when they're children, automatically, though, you have to reapply for guardianship. Now, you're in New York, just to clarify, but I believe that's true also in California. I'm not an attorney, but you have to think about that process, and there's a transition, be ready for that transition process, correct?
Exactly. And a lot of parents don't think about that. Like all of us, special needs children or no, we don't like to accept when the kids are growing older and no longer need us, or we're no longer authorized to help them in certain areas. So moving for guardianship when a child turns 18 is very important to allow a parent to continue supporting them the way they need to be supported.
Now, call me silly, but it seems to me sometimes children don't want parents to have the control that they need to have. And I can imagine, with a child, they don't have capacity to make those decisions. I imagine in some cases, some of these adults similarly don't have the capacity. They may not want guardianship, but does the court still look at what's their best interest and will consider that in the process?
Yes. So the reason I like the area of guardianship so much is because it's sort of a unique area of law where everybody involved is really most interested in that person's best interests. So regardless of what hat you're wearing in the proceedings, lots of people involved, everybody is trying to figure out what this person needs to be best supported and what is in line with their functional limitations. So what's right for one person is not right for somebody else. And that's one of the most interesting things about guardianship.
Now, you say that everybody is looking out for the best interest of the child, now the subject of guardianship, adult. But my experience is you throw money in and the whole game changes.
You're exactly right. And that rule applies to everything.
Yes.
You throw money in the mix and everything
Yes.
changes. So you
Yes.
throw some money in the mix, regardless of who the guardianship's about. I
Yes.
comes up all the time with older people who haven't planned. When there's money in the mix, now there are new people crawling out of the woodwork with an interest in the proceeding. And there might be arguments among family members about how the money should be managed and where it should be managed. And money does add a whole new dynamic to any kind of proceeding.
And I've seen, expense reports reviewed in court down to we want to, I remember one, Arby's roast beef, I don't know why one stands out, where I forget the term for the person who, I guess the guardian versus who's the person that's being guardianed? Is that's the subject or the?
It's the incapacitated person here in New York.
There you go. So the incapacitated person and the guardian took them on the way to some doctor's appointment. On the way, they stopped off at Arby's roast beef and got a sandwich, a Coke, and fries or something. And the attorney was objecting that the guardian sandwich was included. And the guardian saying, well, yeah, but it was all day because we had to go like an hour and a half into this and waiting. And if it's more than 4 hours, you're allowed to have the meal. But if you're not, if it's on a routine, you don't get the meal paid for. And they spent 15 minutes arguing over, I think it was like a $6 expense of a sandwich and a fry and a Coke. I'm thinking, oh my gosh, between these attorneys and the judge's time, this costing hundreds of dollars. And
Right.
it does sometimes seem to me that when there's money involved, these things degrade into it's kind of the equivalent of the Russian-Ukrainian war. Without regard to what side you're on, there's people dying, and it's like a meat grinder of fighting going on. It seems to me that often these guardianships and conservatorships become kind of like that when there's a lot of money involved.
Yeah, it can definitely happen. I had an ice cream case. There's an ice cream case here in New York.
Sure.
The guardian so the incapacitated person was an older person who really didn't have any family. And the guardian was really their family. And the guardian would take them every Friday for ice cream. But the guardian, who was an attorney, would drive, 2 hours to wherever the person was and then take them out for the day. And that would require an aide and a van and, all of these things to get an ice cream cone. And when those bills for the ice cream cone were submitted, they weren't $5 bills for an ice cream cone. They were large invoices for an entire day getting an ice cream cone because this was the outing for the, incapacitated person. And there were hearings and hearings over the ice cream escapade. But yes, exactly what you're talking about.
And on one side, in fairness, the subject enjoys ice cream. It's nice to go out. On the other side, it's a very expensive process that anybody that might come out of their pocket may object to. And so it's one of those things where you have a battle set up. And then if you can use this to prove the other one's misspending money and there's millions of dollars involved, all the more reason it becomes like a civil war almost.
Exactly. That's when you're really hopeful that you have a great judge. A great judge can really help sort of cut through this stuff.
So, you say that, and as I'm a real estate broker. I'm not an attorney. I've been in many, many courtrooms over probate matters. And it seems to me there's always the law, the letter, the rules, the procedures, the documents, your pleadings, your objections. Are they filed out right? Are they on time? But there always, to me, is the underestimated value of the judge's impression of the attorney. The great attorneys get it. And I think the average ones just don't realize how much discretion the judge has until they lose something that's important to them, and how that has to be worked nonstop. So talk a little bit about the importance of your relationship with the judges. I know the court is, the guardianship court is fairly narrow, so my guess is you're seeing some of the same judges regularly.
Yeah, so in the guardianship part, at least here where I practice in downstate New York, we typically have the same judges practicing in the guardianship part, and they practice there. They sit there a little bit longer than the average judge, which is so valuable because guardianship is, this really specialized niche area with its own set of rules, and having a judge who understands the rules but also has enough experience to have seen different things, understands what's involved in caring for a person with a disability, complying with all the financial and Medicaid rules. If you have a judge who understands all of that, and then can sort of gets good at reading personalities and cutting through the nonsense, it's such a gift to a guardianship.
Yeah. So what are some things that you do to maintain or elevate your relationship with the judges that maybe you see some of your colleagues overlook or not pay as much attention to?
Well, I think because I've been doing this for a long time and I've handled a lot of guardianships, judges really appreciate it when you know what you're doing. They really appreciate it when you're cutting down on their workload because you're submitting documents properly drafted, you're helping them through the process. I also think judges really appreciate when you're brief, when you're concise and brief, and you're not dragging up all of the he said, she said. You're sort of really letting the facts and circumstances follow the rulings.
I'm not an attorney, but I'm often in court on properties, and there are times that I have to make a appeal to a judge on a matter. And what I've learned is as few words as possible,
yes,
as brief as possible. And I watch the other real estate agent, and by nature, we tend to want to talk and talk and talk. And you can just see with each word, the judge is getting more upset. I'm like, yes, keep going, keep going. There's one thing is just keep the ball moving. Do not hold the judge up. They got a long agenda, or if they don't, and they're done, they want a break. They've worked through a long agenda, and they want to get off of that. So number one is kind of keeping things moving. So let's go back a little bit, because one of the things you brought up also, I think, is hard to understand for outsiders, which is the importance of planning, because if the recipient of the inheritance gets assets, those can almost be used against them to qualify for certain resources.
That's right.
And then inevitably they're going to run out. Nobody has, I should say, very few people have enough resources to hold up forever the expenses that are required for many people who have special needs. It sounds like gaming the system to the outsider, right? You could otherwise leave to your child $3 million, $5 million, or not in a certain way, and they end up getting money in the state. On the flip side, though, we've paid taxes for those services, so it's always depending on which side of that equation you're on. If you're the writer of the check, you want to get your tax benefits back. If you're the just a taxpayer, it might bother you. Talk a little bit about why it's important and how you see it benefiting the recipient in the long run.
So it's important because if somebody receives an outright inheritance, right, cash in their pocket, and they are receiving benefits under a program that requires a low income or a low asset level to maintain those benefits, they're going to lose those benefits if they've come into this money, right?
Right.
The other thing that's important to remember is with special needs children, as they age into adulthood, quite a few of the benefits and services they receive cannot be purchased with money. All the money
available.
in the world may not be able to be privately paid for the benefits that they're receiving. So it's important for them to retain their housing, retain their medical coverage, because it follows them and it helps them to live a productive life. So you don't want to mess with that system that's been set up. So it's really important that that money not go into their pocket, but go into the proper vehicle to protect the money, allow them some extras, but not disrupt the services they're receiving.
So, what are some of the tactics in an estate plan that can both provide for some of the extras, but at the same time will not disqualify them from receiving the essential services?
Well, the big one is always the supplemental or special needs trust, which is a trust specifically designed for people who are disabled, and it allows them to hold money, right? There's different kinds, but to make it simple, it allows the trust to hold money on their behalf. They can't be the trustee, rather. There has to be another trustee, and sometimes that's a family member, and sometimes that's a professional. But it has to be administered very carefully, and it allows the supplemental things to be paid for out of this inheritance while not disrupting the benefits that the person's receiving.
So, what are examples of supplemental things they can get versus things they can't get?
So I've had people who have gone on day trips with that money. I've had people who have had family that's able to come and take them. And I described the ice cream story, but similarly, I have family that's able to come take the person out when they require a van and an aide to go with them. And it's a costly endeavor, and that can come out of a supplemental needs trust. Some of the other things that can come out of that trust are purchases for maybe some clothing or a trip or a vacation or some extra help that they're not getting otherwise. The supplemental needs in life.
So these are things that you identify ahead of time and get approved, and then that way they're available for, and obviously the nature of special needs is in many cases each individual person's needs are special, right? Some people need certain things, not other things, and you want to make sure you provide for those particular things. One of the people I know, like me, is not just Jewish, they're religious, or they keep kosher. Well, when they want to eat something, there are some restrictions involved, or they want to go somewhere. Well, there's some restrictions involved, so they can't just go to stay at a Holiday Inn and eat at the breakfast bar, or they can, depends on what's going on there. But there are certain needs that have to be thought of, and sometimes the costs are different. And if families going to fight over those costs, it can become a little bit of a mess. So one of the areas I know that's related to special needs trust in some ways is elder law, right? In some ways you have the same kind of situation where you have somebody who is a human being who has their own sanctity and their own authority, but it's limited, and they're not able to make these decisions on their own at some point in time. And so you're kind of preparing for that, I guess, possibility, or once they reach that, you're trying to deal with it. So talk a little bit about kind of how estate planning is done for, say, spouses or family members who have memory loss issues and other capacity issues, and how similar those are to special needs.
So the planning is very similar. I guess that's sort of how you end up with a practice that does special needs planning and elder law. But the planning is very similar, right? We want to make sure that if the person is inheriting money, which sometimes happens when a spouse passes away or something like that, that the money is going into some sort of a secured account or vehicle, so that that person can continue to enjoy, say, their Medicaid benefits, for example, or if they're in a nursing home, they continue to have their care paid for, but there's a little extra money there for the things that exceed the $50 a month in New York that you're allowed to keep if you're in a nursing home. So that might, again, be a day trip. It might be a trip to the beauty parlor. It might be a visit to have your nails done, or, go to a wedding for a family member or something like that.
How often, so go back to special needs for a second, what percentage of families have the trust set up immediately? Because, boy, I hope this comes across right. You have a special needs child fairly early in life, not maybe at birth, but fairly early years. You can anticipate you're going to have a problem of some sort, or a challenge of some sort that's unusual. And I maintain anybody with children should have an estate plan, and it, so that it may not need a special needs provision in it, but you need to have a plan. And obviously, if you are doing a plan and your child has special needs, you really can't start too early. When should somebody look into preparing, the special needs portions of the estate plan? Is that done right away in estate planning, or do you wait till the child's closer to maturity that you need these things? How does that work?
So there's a couple of different things, right? So if you are a family with a child you're concerned will be a special needs child or an adult with disabilities, it's important to convey that to the estate planning attorney so that we can include a testamentary special needs trust, which means a trust that's created when you die. right? And that's a way of passing a portion of your estate to that child without jeopardizing their benefits. And that,
So just another, so that would be, as soon as you set up your estate plan, if you happen to have a special needs child, the only way to do it correctly is with the special needs provision from the get-go.
I would always do that. And don't forget that every family with young children should have an estate plan out of the gate, because you want.
Oh, that's why I have this podcast. I get everybody should have, if you have a house or you have a child, you should have a plan.
Yeah.
So there you go. Simple as that. Just if you have a house that you own, any real estate, and in California for sure, or a child, you should have an estate plan. The plan might be just a will. The plan might be documents and a friend or whatever. Most of the time, the document includes some sort of a formal estate plan with an attorney. I'm just saying that. That's why I'm sorry, I'll interrupt you, but that's a soapbox I'm on all the time.
Me too. So any family with a young child should be making sure they're putting guardians in place and somebody to take care of money to support that child if they die before the child reaches the age of majority. But for those families with special needs children, we want to make sure we're adding extra provisions so that if there is any distribution, the child is still protected with their benefits. Now, if a family has assets or a child is expected to receive an inheritance, there's money coming in from a grandparent or a malpractice suit or something like that, we can set up what's called a freestanding trust, which is not a part of the parent's estate, but a trust set up just for the benefit of that child that's funded with money that either comes to the child through, say, a malpractice suit, when it happens a lot, or comes, through family members into a trust set up for that child's benefit.
I've seen this. I saw this with an automobile accident settlement where
Yes.
they were perfectly healthy and then not and needed additional help, and the money was put into a trust that gave them kind of additional protections and some things we talked about.
Yes, exactly.
Okay, so again, just to recap back for those that are sort of simpler, if everybody should have an estate plan that has children, and if your child has special needs, and I guess when you say special needs, that's broadly speaking. Sometimes kids grow into things or they grow out of things, but we want to plan ahead, and so that's something for the attorney to know about and make an appropriate legal assessment. Right? We don't know medically. You hope things. Whatever, again, I'm talking more about medical versus, say, mental cases. But there are cases we hope people, improve and recover fully medically. But if they don't, that's a whole other special need, right? When people have medical issues that need particular attention and they're not able to take care of themselves as a result.
Yes. I mean, I've handled cases where there have been severe traumatic brain injuries and somebody that will have to live in a facility for the rest of their life. And that trust was able to pay for specialized wheelchairs and computer equipment, right, so they can communicate. So, great needs. And then I've done special needs planning for kids who are maybe on the autism spectrum, and they're going to be able to function to some degree independently, but not completely.
Right.
And we want to make sure the protection is there.
Yeah, I think with those, that's probably the case of the person where you're hoping with medicine, a treatment, maybe that changes, and nobody wants to say, you're doomed forever to have any medical problem. We always hope people have recovery, but we want to plan for the possibility that it is what it is or it gets worse, right, so that we're prepared in case things don't go well and we don't make it worse than it has to be.
That's absolutely right.
Okay. So good. So there we talk about a bit of estate planning, and elder law somewhat kind of overlaps a little bit with that. Let's talk a little bit about the business of law and estate planning practice. You're a sole proprietor?
I am.
And so can you share, obviously everybody would like to be in a position where business just comes at you nonstop and all we're doing is handling that. But I just find even with the best attorneys, that's not the case. There's a certain amount of activity that goes into generating business, so you can pick and choose. Can you describe what percentage of your day or week is on, say, business generation or developing new relationships versus the practice of law and the administrative duties?
So I would say that the networking, I do a lot of networking, and that's how a lot of my work comes through networking relationships that I've built over the years. And I'd say I probably spend about 25 to 30% of my time networking in one form or another. I just came from breakfast with some friends I met at a networking group. So
Nice.
I do that a few days a week. And, that's a very big part, not just of the clients coming to me and the referrals coming to me, but also in my being able to build a team to help my clients as fully as possible. I work with trust companies and professional trustees and financial advisors and all kinds of other professionals who can provide my clients with well-rounded services.
One of the groups people looking to work with attorneys often are real estate agents, maybe not as much with special needs, but maybe more traditional real estate. And I would say to them, rather than cold calling attorneys and asking for leads, try to find where you can create value for the attorneys that you want to work with. So what are things that a real estate agent can do for you, or is there anything they can do for you as far as providing for your resources for your practice, as far as being part of your team or being part of the value proposition to your customers?
So, an agent that understands how estate planning fits into the process of buying a house, for example, if they're representing young families who are buying property, is it possible that they can work into the conversation how important it is now that you're buying a house to speak to somebody about creating a will or a trust? Having real estate agents who understand that they can add value by creating the same team for their clients,
100%.
and assets that way.
And to me, that's just such low-hanging fruit. Like, anytime you work with a buyer, you know how they're going to take title. As a real estate agent, we write on the contract, Bob and Mary Smith or the Bob and Mary Smith Trust is one or the other. We know from the time they write their first offer on the first property, even when they're being pre-qualified, if they don't have it, if the bank account says in their name, notice the bank account's in your name, do you know the advantage of an estate plan and why, when you're buying a house, it's important to consider this. One of the things, I don't know if it's as common in New York as is in California, but so many estate plans are done where the assets aren't funded into the estate. And so now you have a house that's in Bob and Mary's name and you have this fancy trust with no assets in it. And I would say, well, the time to do this, if you can, is while you're looking, so that when you buy the property, it's deeded in the trust, it has title insurance in the trust. That's the most secure way to do that. How are your thoughts on that process?
Well, I always tell my clients, right, when they come to me and they set up a plan and we create a trust, I always tell them, when you buy the vacation home of your dreams, when you go and you buy your condo in Vegas or whatever your dream may be, remember to call me first, because you really don't want assets outside of your trust if we've created a whole estate plan based on assets being in your trust.
Right.
So, give me a call and let me tell you how to do that. And it's super easy, like you just described. If you tell your realtor and the title company, hey, I have a trust, I need to title this into the trust, it goes right in.
It's not a big deal. It's really not a big deal at all. It gets done. They draw the deed right. You set the attorney to verify or whatever if you want to do that. But it's not. But doing it afterwards. So as a real estate agent, there's nothing like you talk to the customer about selling their property and you say, I noticed you don't have a trust. Oh, no, we have it in a trust. Are you sure? Because I pulled the title report. Like, I know the answer. I'm being polite. Yeah. And they'll pull out the fancy booklet with all the documents, and they'll even pull out the deed the attorney prepared them that they never signed and never got recorded. So, which is kind of like having a nice safe in your house, but you put your gold bricks on top of the safe instead of in the safe, and close the door and lock the door.
Right. You leave the door open to the safe, for easy access. So not, a trust has a little homework involved. And I always explain that you have to be willing to do a little homework when you create a trust. It's a great benefit to your family, but let's make sure it's handled properly. And that's a perfect example of not handling it properly. Yeah,
and then you discover, now in California, we do have a process where you can kind of put the gold bars in the safe after the fact. Of course, for California, everything has to be unique here. But I don't think any other state has that provision. And as a result, if it's not in the trust, it's not in the trust. And I think you're pretty much stuck at that point in New York. Is that the case?
So in New York, we do something called a pour-over will.
Correct, yes.
Like it sounds, pour-over will, like pouring a teapot. And you pour the assets you've left out into the trust after your death. But there still has to be a legal process to do that. So if you funded the trust properly at the setup and then bought one other thing that's outside the trust, the good news is the proceeding's limited to that one thing. The bad news is there has to be a proceeding.
Good news is you only need one legal procedure. Bad news is you need a legal procedure.
Exactly.
Yeah, and it's interesting. In California, we call it a Hegstead petition, where you can get that deed, if it's the intention and you can prove it and blah blah blah. But the challenge there is like right now, if you file in LA County, a probate filing from file date to first hearing is about 35 days on average. On a Hegstead petition hearing, an 850 hearing, just the filing date is 6 months out from the day you file. So it's easier, but it just takes 6 months. And then, by the way, because it's a little specialized, attorneys charge almost as much as they do on a probate. So it's kind of like, it's easier, but it's not. It's faster, but it's not. How about let's just get it right the first time?
Yeah, exactly.
And so I think as real estate agents, I always try to encourage my agents to, at the purchase, verify up front. So you get that done, and you might offer them a estate plan process to get it done during their home buying process. Sellers, you want to check the documents right away. And then I think for past client development, we should be going online, identifying where our customers are and pointing out to them, hey, I noticed that I sold this house 5 years ago and it's still deeded in your name. So you guys not familiar with the advantages of a estate plan. So if somebody wanted to talk to you about estate planning, what's the kind of the doorway in? What's the first step on working with you and considering you as a resource? You do, today we talked about guardianships and conservatorships and elder law a little bit, but you also do standard estate plans. It's all part of that mix, correct?
Of course, yeah.
So if somebody had, if they have particular needs, special needs trusts, or in general estate planning, what's the first step? Is it a call to you, or a consult, or do you do webinars, or what's the first step to start working with you?
So people can call or they can email me, and they can also send a request through my website, and we'll obviously get back with them, and we'll send them a brief introduction form to get some basic information about what their goals are, and we'll set up a consultation. Most of our initial consultations are on Zoom because most people find that most convenient, but we can also do that in person.
And if they use you for an estate plan, will their daughter look that cute?
Everybody gets a daughter that looks that cute with their estate plan.
Now, my daughter looked that cute when she was that age, just for the record. Now she's older and has kids, but she did actually look. That is one cute little girl. Okay, so it's JackieCaraLaw.com as a website. We also have it down below in the banner ad. And then on there you can click to start planning and or make a phone call and get set up and talk to her. And then again, one of the focuses of her practice is special needs trust, an area that she's really an expert in and has put some time and effort into providing some extra value. So Jackie, I always learn so much when we talk. I really appreciate your time today. Thank you so much for being on Probate Weekly.
Thanks, Bill. It was great to be here.
And for the rest of you, this is Probate Weekly. We do this weekly, a new episode, talking to attorneys primarily, but vendors as well across the country to be more effective in our business. If I can help, I'm at Bill Gross Probate on social media. You can reach out, call, text, or email. If you like this, you have comments, please put the comments below. And also, I would say if you know somebody who you think I should interview for the program, please feel free to make those suggestions. We're always looking for great guests as well. I'm at Bill Gross Probate. You can continue the conversation on our Facebook group, Probate Weekly. You can go there if you have referrals out of state, out of the area for realtors, for attorneys, or just general questions. We have attorneys who monitor the messages there all the time. So again, thank you so much. And as always, make today your best day ever.